We now turn to the fourth case on this morning's docket. It is case number 104020, State of Kansas versus Sergio Cervantes Puentes.
Calling Assistant Counsel Michelle Davis. Could I please reserve 2 minutes for rebuttal?
2 minutes.
Yes.
That's granted.
This is a case where the appellant was convicted. It was a department store in Wichita. He was convicted of one-time rubbing or touching of his groin area against the back or the butt area of a 13-year-old girl. And for that, he was convicted of aggravated indecent liberties with a child and sentenced to life in prison. I think the thing that jumps out at you about this case is the length of the sentence. The life sentence based upon this was a one-time sexual contact.
You filed the defendant filed a motion for departure.
Yes.
It was denied, and you didn't appeal any issue with the departure. Is that right?
Yes. I actually didn't write the brief in this case, but yes.
No, I understand you didn't write it.
The attorney that did write the brief is not in there.
But in reviewing that, that's really not under our review.
Yes, you're correct, Justice.
And so it's just a constitutional claim on, not just a constitutional claim on.
Yeah, just. That's a big word. Yes.
Solely.
Thank you. But
Just that
your real complaint here is the departure, isn't it? That you didn't raise on appeal. I mean, you had your opportunity to say the facts under this case. And I read the departure motion and the court's ruling, and the court denied. And it's basically the argument you're raising right now was included in the departure motion. Isn't that the most appropriate forum to raise that? Maybe not appropriate, but the way that we would reach that.
Well, yeah, there's two parts to that. I mean, obviously one is the departure, but that is totally a discretionary decision by the district court. And as long as the district court properly weighs the law and weighs the factors and decides that there aren't substantial and compelling reasons, then that's affirmed on appeal. So in terms of the ability to really argue that on appeal, I think it's pretty limited, but I would concede your point that we didn't argue that part. So really the only other part that's left is the constitutional part. And we did raise that issue in terms of there are two parts to the constitutional challenge, and we did raise those in the brief. And the first is obviously that, as you're saying, based on the facts of this case and the circumstances, that it's disproportionate. And then the second part, under the Eighth Amendment, is that there's a category of offenders to whom application of a life sentence is cruel and unusual disproportionate punishment. And in our brief, we raised the category that it would be a first-time offender, and the category would be the offense itself, which is a touching, as opposed to a rape case. That they would be, in this case, it was just a touching. Basically, the statute aggravated indecent liberties prohibits a touching or a fondling.
When you start talking about those facts, how does it still remain a categorical challenge? Why isn't it a challenge that falls under the Freeman analysis or a similar Eighth Amendment analysis as a case-specific challenge?
Well, it does. It does fall under the Freeman case-specific. But as a category of offenders, people who commit this crime, by the nature of the offense, are guilty of a fondling or touching. And this court said, I believe it's in, this court has not applied an Eighth Amendment categorical to a life in prison sentence, but you have applied it to a post-release, lifetime post-release, and that was in Mossman.
I don't think you've answered my question, though.
I'm trying to get there. In Mossman, you said that. In Mossman, you said that the class of offenders would be first-time offenders, and also that everybody who commits this crime.
Right.
Because I think in Mossman, they were trying to tailor it more narrowly. And this court said that no, it has to be, the category has to be everybody who commits this particular crime.
And so you're saying you're not trying to narrow this crime, you're just trying to compare it to other sexually violent offenses.
Yes, for example, like rape, where there's sexual intercourse, or an offense involving force would be different, because this crime does not require any force or any coercion.
It doesn't require it, but it doesn't prohibit it either. I mean,
true.
that's
true.
where you start talking about facts specific to how the crime was accomplished. And that, I believe, takes us out of the categorical challenge.
But I'm not basing it on the facts of this case. If you're under a categorical, it would just be any fondling or touching of a minor with a sexual touching, basically, would be a reading of the statute. So it wouldn't relate to the facts of this case.
As long as you stay there. But then when you start saying that, but there was no force used.
Well, just because the statute doesn't require that. And the only reason I'm bringing that up, Justice Luker, is because at the back of our brief, there are statutes from other states. And part of that is to compare. In a categorical challenge, you have to say, is there a consensus for life in prison? And some of those statutes do talk about force and coercion. And so in order to adequately compare, if we're going to do a comparison like that. And I think that's where it really jumps out at you about this crime. And just to give you an example, if Mr. Cervantes Puentes had committed this offense in 11 other states, he would have been found guilty of a misdemeanor. And, I mean, those states are, and they're listed in the back of our brief: Arkansas, Alabama, Michigan. In Kansas, it's a life sentence. If he does this in New Hampshire, New York, North Carolina, if he done it in Oregon, Virginia, Pennsylvania, or West Virginia, it was a misdemeanor. That's pretty disproportionate. In Kansas, of course, if this girl, who was 13 years old, if she had been 16 or older, then it would have been a sexual battery. It would have been a misdemeanor. So I think not only the 11 states, this would only be a misdemeanor, but if you look at many of them, if you look at the back of our brief and the statutes from the other states, many of them, they classify it the way Kansas used to. It was an A, B, C, D, or E felony before the sentencing guidelines came into effect, and the most severe was an A. Many of them classify it as C, D felonies. They're low to medium level felonies. For example, California, it's a felony, but it's punishable by a medium term of 6 years. Georgia, it's 1 to 5. There's numerous states, Mississippi, Minnesota, Massachusetts, where it's a sentence up to 10 years. So even when it's a felony, your cap's at 15 years. So Kansas is one of only a very few states that impose life in prison for sexual contact. We're not talking rape. We're talking sexual contact with a minor. And I think that...
contact with the sexual purpose.
Yes. Yes, you're correct, Justice Johnson, because it doesn't have to be a sexual type touching. It doesn't have to be of a private part. It just has to be a touching that has is judged to have a sexual purpose. So I think it really jumps out at you that Kansas is so severe, and in a very small, our brief says 4 altogether states, that for sexual contact with a minor that impose a life sentence. That's very disproportionate. I do want to, Justice Luker, you asked about the proportionality. I do have to concede that the trial judge did not make the findings under the first part of the Freeman test. It was raised by the defense in the motion, but the judge did not make any factual findings. And it's my understanding that this court will not, therefore, review that Freeman first factor. So I think I'm sort of limited in the way to raising this that you're going to address this perhaps as categorical and not as a disproportionate based on the specifics of this case for that reason. I would rely upon the arguments that are in our brief on remaining issues, and that would conclude my comments.
We have any questions of counsel? Thank you, counsel.
Thank you very much.
May it please the Court, Assistant District Attorney Matt Maloney for the state. I'll also limit my remarks to the sentencing issues unless this Court has any other questions on the remaining claim. I think that there are obviously two separate issues raised in the brief, one being under the Freeman analysis and then one being under the Eighth Amendment to the U.S. Constitution. It appears counsel has acknowledged that the Freeman issue has more or less been waived because the defense did not ensure that there were adequate findings made by the district court on that test, or at least on some of those factors. Be that as it may, I would agree, or I would pick up on some of the questions that Justice Lukert was asking counsel, in that while they are briefed as separate issues, in reality that the argument that's made in the brief and again on appeal basically does intertwine what is attempting to be a categorical challenge with a argument that really is case specific. Now, with respect to the U.S. constitutional challenge, one of the first things that we see is the nature of the offense here. And the nature of the offense is plain and simple. It's aggravated indecent liberties with a child, period. There's no consideration of the facts, whether this person did this or that. It's purely the crime of conviction. And this court did hold that in Mossman, which I did cite in a 609 letter that I filed. So I think that issue has been recently resolved by this court, and so we cannot look at any particular facts of this case and say, well, this was an act that occurred that didn't involve penetration, it didn't involve force, it was something that was just a touching. None of that is relevant with respect to the U.S. constitutional challenge.
The penetration is, because that's not ag indecent liberties, is it?
Well, penetration is not a requirement, although, as Justice Lukert pointed out, it's not prohibited. You could be convicted of that. I think you could be convicted of ag indecent liberties even if there was penetration. So to that extent, there still is a factual issue there. But I would obviously acknowledge that, of course, penetration is not an element of aggravated indecent liberties. But my overall point is that counsel, in trying to limit the nature of the offense, is making very much a fact-specific argument, and that is not appropriate in a categorical analysis. As to the class of offenders, I think that counsel has argued that this is a first-time offender, and I would take issue to that to the extent that this defendant did have multiple prior convictions for what I think could be easily categorized as sex-related offenses. I cite in the brief that he had 3 prior convictions for public indecency and exposure. He also had a prior conviction for lewd and lascivious behavior. So to suggest that he was a first-time offender just because he didn't have a prior conviction of this specific offense, I think would be to take an unreasonably narrow view of what you consider a first-time offender to be. I think if you were to extend that, you could say that if he's convicted of aggravated indecent liberties in this case and then comes back in the future and is convicted of rape, you could say that he's still a first-time offender because it's a different specific crime. I would argue that he was not a first-time sex offender, and in fact his conduct had been steadily escalating, going from lewd and lascivious, public indecency, and now aggravated indecent liberties with a child. So I would argue that not only the nature of the offense, but that the category of offender that the defendant is trying to get this court to analyze the case under are both incorrect. This court, obviously, in the 18 or 19 months since this case was briefed, you've addressed numerous Jessica's Law challenges. I did file a 609 letter where I cited Mossman and Cameron. I tried to cite the cases that I thought were perhaps most relevant. Obviously, in a 300-word limit, I was not able to cite every opinion that this court has released in the last year and a half. But I would ask this court, I would argue that there's really nothing being presented in this case that this court has not already addressed in numerous cases. And I don't know that I have a lot to add to what this court has said in its prior opinions on this matter. Obviously, our position is that the sentence was not unconstitutional, that the categorical challenge would fail based on this court's own prior case law. And again, I think that when you look at the arguments that are raised in the defendant's brief and you compare them with the issues raised in Mossman and Cameron and a lot of the other cases that have been recently released, you really don't see any new arguments. Specifically, the defendant relies a lot upon this comparison with second-degree murder to say that...
Well, let's compare with first-degree murder. If this defendant had formed or planned the design to kill this 13-year-old victim, and instead of having rubbed his clothed body up against the back of her clothed body, he had grabbed her, slit her throat, and killed her intentionally with premeditation, the sentence would have been exactly the same as he received for rubbing up against her. Is that correct? A hard 25 for premeditated first degree and a hard 25 for Jessica's law.
I believe that's correct, Your Honor. I think that I was trying to remember whether it was hard 25 or hard 40. I always get hard 25, hard 40 mixed up there, but
well, let's assume they are exactly the same sentence, and we won't even go into good time credits or anything like that. But let's just assume they're the same. And does that give you pause on proportionality?
It doesn't. I think, first of all, it would give me pause perhaps if you were saying that the first-degree premeditated murder sentence were less severe. But I don't think that just saying that it's the same for another crime that some would say is a more serious crime, or that is a more serious crime. I don't think that that's necessarily enough to give me pause. Again, if we're a situation where a clearly more serious crime were punished less severely, then that would be a different set of facts. But as I thought about that type of question as I prepared for argument, I realized that the type of question that you're asking could easily apply to any crime on the guideline, because obviously within any severity level of crimes, there are going to be all sorts of crimes. And we could sit there all day and try and line them up and say, within severity level 3, this crime is more severe than that crime is more severe than this crime. Yet, within that severity level, they all receive the same punishment. We would have an infinite number of levels of severity levels if we were wanting to go and look at each individual crime and then say, well, this is slightly more. And your case law reflects...
But does that make any difference on our categorical analysis if they run the gamut, if they make, say, the hard 25 apply to this crime that includes the gamut of from here to here? Is that have constitutional implications if the culpability or the seriousness of the crime is broadened by the classification of the crime? You understand what I'm saying?
I think I do.
We're comparing, ag indecent liberties with second-degree murder or whatever. What if we are looking at the category of aggravated indecent liberties carries with it a hard 25 life sentence, but from a categorical standpoint, that's not permissible because it includes everything from winking at someone to serious sexual attack. That category shouldn't be. If you broaden the category too wide, does that bring in the Eighth Amendment, is my question.
Sure. Well, I think a couple of things. One, as I indicated, this court recently decided that is an appropriate category. It's just confining it to the offense itself without looking at the facts. Now, obviously, in a hypothetical world, certainly a category could conceivably get too broad, but what's happening in this case, and at least is what the defendant is asking, is for you to go the other way and make the category way too narrow, and to say, well, this crime was ag indecent. It happened without force, without coercion, without penetration. We could take it to ridiculous extremes and start talking about what day of the week the crime occurred or what color clothing he was wearing. I mean, you get my point, I'm sure, is that you could go into either extreme, whether it's too broad or too narrow, but I think that this court has properly defined that nature of the offense and limited it to ag indecent liberties. And so I would urge this court not to then get back into the factual issue of what actually happened based on the facts of this particular case. That's an argument that would have been properly raised as a case-specific challenge under the Eighth Amendment or under the Freeman test. But they didn't raise the case-specific challenge under the U.S. Constitution, and the Freeman factors have been waived because there weren't sufficient findings made by the district court below. So I think that we are confined, and furthermore, I think in this court's analysis of the comparison with second-degree murder, the court did note that the actual comparison should probably be looking at murder as a whole, and the court noted that when you compare it to first-degree murder, then all of a sudden you don't have this concern about, well, he's being punished more severely than a murderer. And the court also indicated that there's never been any indication that there's this linear ranking of crimes that holds that all murders are in fact more severe than all sex crimes. And again, I would just urge this court to follow its own recent precedent.
There's a little bit of that in the U.S. Supreme Court, where they initially started with disproportionality applying only to murder cases.
True, and obviously it has now extended and
yeah. But anyway, there has been some indication from the U.S. Supreme Court that murder is a different crime. Hasn't there? I mean, and excluding juveniles and doing that. And, what I'm trying to say is there's been some recognition by the U.S. Supreme Court that murder is different.
Sure. I would argue that I think there's also been some recognition, as your own opinions reflect, that sex crimes also are a separate class of offenses, and this court's opinions reflect the fact and cite a lot of the reasons why, being the high rate of recidivism and the need to protect people from these types of offenders. The defense, in the brief at least, places a lot of emphasis on the fact that, well, the victim here suffered no physical harm. Again, I would argue that that's analysis more appropriate for a case-specific challenge, but be that as it may, I would note that obviously while there might not have been any specific physical harm, certainly I think we can all acknowledge that there would be tremendous emotional and psychological harm in a case like this, where this happened in what theoretically should be a safe place. This victim was in the middle of a public department store and suffered this crime, and clearly that would be something that I would think would have lingering emotional after effects for quite some time for the victim. So I think that I would ask this court not to get too wrapped up in the defendant's attempt to make this into a case-specific argument wrapped within the categorical challenge. I would ask this court not to look at the facts of the specific case, because the only issue that is properly before it is the categorical challenge. And again, this court has told us that the nature of the offense is aggravated indecent liberties, no narrower than that. And with respect to the class of offenders, I think it would be inappropriate to classify this defendant as a first-time offender, given his criminal history and some of those prior offenses that I recited for you and that I did cite in the brief. Beyond that, again, I don't know that I have much that I can add to what this court's recent opinions have held, and I would just ask the court to follow that analysis and to reject the categorical challenge that the defendant has lodged. If there are no other questions, I would respectfully request that the defendant's conviction and sentence be affirmed.
Any further questions of counsel? Thank you, counsel. Reserve 2 minutes for rebuttal.
I think just on the categorical, the rationale you use to uphold lifetime post-release in Cameron and Mossman, because there's a two-part test, and one is the national consensus about the punishment for this crime, and that's where I talked about the other states. But the second part is that you're supposed to exercise your independent judgment and look at the purposes and whether the purposes of rehabilitation and deterrence and incapacitation, et cetera, are served. In the cases that the state talked about, Mossman and Cameron, where you found there was a penological purpose for lifetime post-release, it's a little different when you're talking life in prison, because you upheld lifetime post-release under some of those, for some of those reasons, that it was justified. And I think it's different looking at this from, in terms of retribution, a life sentence. It's different than how you look at it in terms of lifetime post-release. Just wanted to point that out.
Any further presentation, counsel?
No, thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement. That concludes this morning's docket. We are in recess until 9 o'clock tomorrow morning.